Okay. Welcome back, everyone. Today we're going to be focusing on 3 categories of criminal behavior: attempt, solicitation, and conspiracy. Before we begin, it's important to note that these categories are often attached to other criminal charges. Both solicitation and conspiracy can stand on their own, separate from the crimes like burglary or larceny. Keep in mind that we will still be focusing on the group dynamic that we examined in the last lecture when we discussed parties to crime. On that note, let's explore how these criminal classifications apply to the broader realm of criminal behavior. To begin with, when we have this discussion about categories of crime, we have to focus it within the sphere of what we call inchoate crimes, or beginning crimes. If these are beginning crimes, which means that there is more to come. This is one of the reasons why these are separate crimes from the actual crime that is committed later. You might not actually get to commit the crime, or you might get caught trying to do it. So think of this lecture as all of the prep work that is needed to go out and commit all of the specific crimes that we're going to discuss in later lectures. So when we have these 3 types of crimes that we've addressed briefly already: attempt, or an incomplete or unfinished crime; conspiracy, which means that we're working together in agreement to complete a crime; and solicitation. This is me asking you to work with me or for me to commit a specific crime like burglary for you. We're going to begin with attempt. Attempts are a little different than solicitation and conspiracy. You are not going to be charged with attempted murder and then murder. You're either successful in your attempt, meaning that the crime was completed, or you have failed. It's either one or the other here. If you do fail in trying to complete the chosen crime, there's a few ways in which you can fail. So let's begin with our discussion of a complete attempt. This does not mean the same thing as a completed and successful crime. This is a term that signifies I have tried everything in my power to make sure that the attempt is successful, but I still fail. For example, let's say I want to kill you. I have fired the gun, but I missed the intended target because I'm a bad shot, or because you ducked, or something like that. Or I tried to break into the safe at the bank, but there's no money inside it, so I wouldn't be able to steal the money. And finally, let's say that I tried to use a stolen credit card, but there's a fraud alert issued, and the card has been deactivated before I can even use it. The failure is no fault of your own. Something else has occurred which prevents your success from happening. But you have put all of your ducks in a row, and it still doesn't work out for you. That's a complete attempt. Remember, don't confuse this with a successful completion of the crime. This is still a failure by all accounts. Next, we have an incomplete attempt. This means that you're nowhere near the success marker. Even though I initially wanted to commit this crime, something has happened and I'm not able to complete my actions. Maybe I abandon the effort, the police walk by, I get apprehended, or something else prevents me from completing the attempt. So for example, let's say an offender is about to burglarize a house and then he has a change of heart. Or a rapist has decided to rape someone but cannot become sexually aroused and runs away. Or the police see you trying to break into a car and they stop you before you can complete that theft. Finally, we have impossible attempts. Basically, no matter how hard I try, I will never be able to complete this crime because something has happened to stop me from being successful. I might even be the reason why I'm not successful. This could be a problem on my end because I didn't plan it out correctly, or there was no way that this would have worked due to unforeseen consequences. So let's think of a few examples here. Maybe I forget to load my gun so I can't shoot you. If there's no bullets in the gun, I'll never be able to successfully kill you that way. Let's say I'm going to rob the Brinks truck, but somebody gives me bad information and the Brinks truck never shows up, so I'm unable to rob it. How can I rob the truck if it never shows up? But I'm there ready to do it, so I still tried. I didn't buy any fuses, so I can't ignite this bomb. You can see here that through these examples that something has occurred in order for me to not be successful in any way here. I would remember some of these examples and figure out why each one of these fits into the category that they fit. Also, using these examples, what would need to happen for them to fit in one of the other attempt categories? These are the types of connections that you should be making as we make our way through this material. In the discussion of these three varieties of attempts, we have discussed proximity to completion and to the success of the crime. But how close is actually close enough? No matter the type of attempt that I end up committing, have I done enough to prove the elements of attempt? So I intended to commit the crime and I took enough steps to complete it. Let's say I bought the gun, I showed up to the bank, I held the victim down, but then something happens and I fail. Is that close enough? Or was it close enough just to buy the gun? Or do I actually have to make physical contact with somebody in order for the attempt to prove? The big question is really, what do clear steps actually entail? There are a few items that commonly fit the mold of what we call clear steps. You could be lying in wait for the victim. You could be surveilling the store that you want to rob or the house that you want to burgle. You could be trespassing to try and unlawfully enter a structure. You could be in possession of the items needed for the crime, like a lock-picking kit, firearms, bomb-making materials, or anything else that would help you commit this crime. You could even try to solicit a co-conspirator. But it just so happens that the person you are trying to solicit is actually an undercover officer, for instance. The court has had two different discussions regarding how close is close enough to prove attempts. In the first case, People v. Rizzo, we saw a case that involved an impossible attempt. The defendant and three men decide that they were going to rob an individual who worked for a large company. The man that they were going to rob was in charge of the payroll, and every Friday he walked a similar route carrying the payroll. This was before companies used armored trucks and had the internet just to transfer payroll funds over. Anyway, the men were lying in wait for the payroll, but it never comes by. So they wait some more, and the police see them waiting for this guy to come by. It was just happenstance that the police are even there, but they see this man, they hear them talking, and it's clear that they're trying to get the payroll employee. The men start to move, and the police trail them. They follow them into a building. The men were then arrested, and they were charged with attempted robbery, even though the individual that they wanted to rob was nowhere nearby. The men never even see the employee that they are trying to rob. But the rationale of this case was that if the police had not intervened, it was likely that the men would have searched for the intended victim until they found him and the payroll. So how close are the defendants to actually completing the crime? The physical proximity test would suggest that I have to be as close as possible in order for the attempt to be proven. So, if I'm going to rob the Brinks truck, but I never find the Brinks truck or it drives off as I'm getting out of the car with my gun. On the flip side, the substantial steps test has a lot less of a burden to prove. In the case of Commonwealth v. Gilliam, we see that Mr. Gilliam was a lot less successful than Mr. Rizzo and his friends. Gilliam was a prisoner in Pennsylvania who began to cut through the prison bars of his cell. He didn't get all the way through the bars, and he even tried to hold them together so that the correctional officers would not see what was going on. He never tried to climb out of the windows, but after a search of the cell, the correctional officers found the tools that he was using to cut through the window. He wasn't anywhere near ready to get through the window or to make his escape, to get through the walls, but the court stated that because he took steps to escape, that was enough for the attempt requirement to be fulfilled. This case asks whether an individual has taken affirmative actions towards the completion of a crime that, in combination with other evidence, indicates that a defendant possesses a criminal intent. There is no requirement to be physically proximate or even close to the offense, and no distinction is made between preparation and perpetration of the offense. So, if I tried to cut through the bars of my prison cell to escape, I have committed a substantial step towards my escape, but I am nowhere close to actually completing the attempt. Even though we have discussed impossibilities a bit already, we need to explore this topic more in depth as there are several varieties of legal impossibilities that can actually happen. First, we have a factual impossibility. This occurs when something happens right before the crime to make the attempt impossible. In other words, I try to shoot through the wall thinking you're on the other side of it, but you recently moved into the other room. I still think that you're standing right behind that wall I'm shooting through, and without knowledge that you have moved, I still think you're there, and I'm trying to kill you anyway. It is factually impossible to kill you, but I don't know that to be true. Next, we have a legal impossibility. In this category, the thing that you're trying to do is not illegal, but you believe it is. So, for example, let's say you're trying to buy cocaine from an undercover officer, but all that cocaine is really cornstarch. It's not illegal to buy a bag of cornstarch, but it is illegal to try to buy cocaine from an undercover officer. Therefore, even though the purchase was legal, the intent was not meant for that legal purchase. Instead, my intent was to buy narcotics, which is 100% illegal. Finally, we have things that fit into the category of an inherent impossibility. So this means that no matter what you do, your actions will never result in committing the desired crime. So let's think of a few examples here. Your book actually gives an example of killing someone through stabbing a voodoo doll. Realistically, no matter how many times I stab that voodoo doll and hope that my husband will die as a result of the stabbing, it's not going to happen. So what about something more realistic and more commonplace? Let's say I enter a chat room and I try to meet up with an underage minor for sex. But I don't know that the person I'm talking to is really a police officer working a sex sting. I believe that I'm talking to a minor, but no matter how much I talk, and even if I arrange a meeting between us, that minor is never going to show up because that minor doesn't exist. Or finally, what if I decide that I am going to kill you and I shoot you in the head multiple times? Well, that certainly sounds like I've been successful, but what I didn't know was that you had a heart attack an hour before and you're already dead. How can you murder someone who's already died? You can't. But if you didn't have that knowledge and you still tried to do it, then you're still liable for attempted murder. These distinctions are important to remember, as you might see them again later on as we discuss specific crimes more in depth this semester. As I told you before, try and think about how these examples would need to change in order to fit within the categories of impossibilities. We recently talked about abandonment when we discussed incomplete attempts. But abandonment doesn't just describe forfeiting the crime voluntarily. In order to not be held liable for the crime, I have to have a complete change of heart in order for abandonment to actually count. I have to give up and go home voluntarily. I cannot give up and go home because the police show up and I'm trying to run away. That doesn't fit here. If there's an extraneous factor, meaning that something happens that thwarts my attempt without me realizing it, then I am still liable. It could be the police who thwart you, or it's possible that the victim is not where he or she is supposed to be when I'm trying to commit my crime. I might abandon the attempt because things aren't lining up correctly, but you are still liable here. You didn't have a change of heart. You just didn't plan very well. So unless it's a voluntary gesture because you genuinely felt bad, the attempt still occurred and you're still liable. So now we're going to switch gears a little bit and we're going to move away from attempt. In exploring solicitation, you need to think about it in terms of a request or of a question. Solicitation happens every day in all types of legal forms. Think about all the phone calls you receive from telemarketers who are calling to tell you that you just want a cruise, right? They're trying to get you to buy something from them. But there's always some sort of incentive available to try and get you to comply with their request. The same is true when we talk about criminal solicitation. Criminal solicitation involves me asking you if you want to commit the crime with me, or I'm trying to get you to do the crime for me, a crime for hire type of situation. You don't have to agree in order for me to be held liable for soliciting. As soon as the question is asked or the request is made, then now I am liable for solicitation. But it's hard to prove that I actually did solicit you without some sort of proof. If I asked you to kill someone for me and you don't have any evidence that I did ask you that question, then that's really your word against mine. But as soon as you agree to my request, we have just entered a conspiracy and now you're liable as well. We will discuss conspiracies in just a few minutes. Solicitation can take place during a conversation that the two of us are having. However, the most transparent types of solicitation take place in an undercover sting operation. We hear about these stings all the time, and you would think that after a while people would be a little bit more suspicious about who they're talking to. But undercover stings are often successful, and they culminate in multiple arrests. It's imperative that law enforcement actually provides evidence that the solicitation occurred. That's why when there are undercover sting operations, they're normally recorded, and they are able to provide transcripts for evidentiary purposes. For example, prostitution stings that take place in hotels are normally videotaped, or online solicitation stings provide chat transcripts. Think of the show To Catch a Predator, when they read the transcripts to the offender to show that he has been caught in the act. Even though that the act is complete upon request, normally officials need something else that makes it clear that you're serious. Will you kill someone for me? Here's the money for that. That shows that I'm serious. An overt act of good faith on the part of the individual who is soliciting to show that they are not just joking. The same overt act is necessary on the part of the individual who actually agrees to the solicitation. Now that I have asked you to commit a crime either with me or for me, we have to talk about your role in this process. As we said before, if you agree to my solicitation, then we have entered a conspiracy. So at the base level, we're going to need 2 people to agree to commit the crime. It can be many more people than that, but at the very least, we need 2 in order for it to qualify. A conspiracy takes place once you agree to my solicitation. As the solicitor, I would be charged with both conspiracy and solicitation. You, as the person who agrees, would only be charged with conspiracy. And once again, we're going to need that overt act to show that the conspiracy is good to go. I ask, you agree, and then as a sign of goodwill, you actually go out and buy a black market gun to kill the intended victim with. Or if I ask you to burglarize a house, you go out and surveil the property for us. The problem with conspiracies that involve a lot of people rests with the unknowns and the motivations of everybody involved. So let's say you only plan to commit a robbery, but your co-conspirators are planning to kill somebody. Would you just be liable for the robbery because that was your intent? Would your co-conspirator be liable for the murder since he was the only one who actually pulled the trigger? How does this work? The Pinkerton Doctrine actually states that an individual is guilty of all criminal acts committed by one of the conspirators in furtherance of the conspiracy, regardless of whether or not the individual aided and abetted or was even aware of the offense. So that means that if I am only aware of the robbery and only intended for the robbery to occur, but my co-conspirators are intent on murdering the victim, then I am liable for both crimes. Everyone in the conspiracy is liable for everything that takes place, regardless of intent or actual personal action. The Pinkerton Doctrine also often accounts for things that were foreseeable during the commission of the crime. But what is worrisome are the things that are in no way a foreseeable progression from the initial crime. For example, it might be foreseeable that someone is killed during a robbery if we have firearms with us. But what about a murder that is committed after a botched graffiti session? That's probably not foreseeable at all. However, there is going to be one exception to the Pinkerton rule. What happens if you're part of a conspiracy, but you're an unwilling member? Think about it this way. Many prostitution and sex trafficking rings often have females who don't want to be prostitutes, but they have been manipulated into the lifestyle. Under the Ghiberti rule, if you are a victim of the conspiracy, meaning that, for instance, you are a sex trafficking victim, you will not be held liable for the actions of the other conspirators. We first see this instance of this being taken place within the Mann Act of 1910, or the White Slave Trafficking Act. This is, in essence, one of the first sex trafficking acts the United States has ever had, and it still currently exists today. The law has been amended multiple times over the years, but originally it stated that it was a felony to engage in any sort of interstate or foreign commerce of any woman or girl for the purpose of prostitution or debauchery or any other type of immoral purpose. But this is kind of a little bit vague, and the wording is really straight out of 1910. What does immorality mean? Who is the victim? Who is the offender? So under this act, women can never be offenders and men can never be victims. But we know that isn't true through the examination of sex trafficking trends that are present today. There have been several famous cases over the years prosecuted under the Mann Act. In 1944, Charlie Chaplin was acquitted after he paid for a train ticket to send his mistress home. She willingly went. She was not a prostitute, she was not coerced, but people at the time felt that it was an immoral practice to, one, have a mistress, and two, to send her away because his wife was upset by her presence. Next, we see that charges were dropped against Charlie Manson after he took 2 prostitutes from California to New Mexico so that they could work for him and send the money back to Charlie. There was not enough evidentiary support to prosecute the charges that were made against him. Finally, the singer Chuck Berry was found guilty in 1962 for transporting a 14-year-old girl across state lines to have sex with her. The Mann Act was amended in 1978 and again in 1986 to speak more about prostitution and sex trafficking issues. The wording of the act moved away from things like immorality and debauchery, which were considered vague and very difficult to prosecute due to the subjectivity of the words. But the important thing to remember here about this law is the inability to prosecute victims or unwilling participants who are involved in the conspiracy. At the beginning of the lecture, I told you that all of these were separate charges. You can be charged with attempt, solicitation, and conspiracy if you are the ringleader of the crime in question. These charges quickly add up for offenders and result in longer prison sentences for all involved when collaboration happens. Next time, we are going to focus on how to get away with the crimes that we commit. Join me back here when we discuss criminal defense. I'll see you then.